In this video, I want to walk through some of the material in Chapter 6, and I have the posting for that chapter up on the screen, and you'll see that we address three different topics in Chapter 6, Statute of Frauds, Parole Evidence Rule, and then a carryover from Chapter 1, Interpretation of Contract Language. And perhaps if there's a unifying theme to this chapter, it would be that we're talking about a written as opposed to a verbal contract. So with that in mind, let's look at the statute of frauds. The law, or if you will, the statute of frauds, is a set of rules that requires that certain contracts to be enforceable are set forth in a signed writing. It's signed by the party against whom we're seeking enforcement, and since when we enter into the contract, we don't know if that day will arrive where enforcement has to be sought against either party, and this only course of action, obviously, is to have all the parties sign the contract, so that it could be later said that it's a written contract signed by the party against whom enforcement is sought. There are various contracts, and they're set forth on page 87 in section 2 of chapter 6 in the book that identify categories of contracts covered by the statute of frauds. Certainly one big one would be a contract involving the transfer of an interest in land. If I were to sell you my house, which would mean we enter into a contract, we wouldn't have any choice if we wanted the contract to be enforceable, but to make certain that contract is in writing and to make certain that both of us sign it. Another category of contract covered by the statute of frauds would be a contract between individuals who are planning on getting married, and in that type of contract, which is known oftentimes as prenup or prenuptial agreement, the parties set forth their agreements regarding how assets will be treated going into the marriage and during the course of the marriage, and sometimes in the event of divorce or death, as you'll see. So that's one category of written contracts, contracts that are required to be in writing and to be signed by virtue of the statute of frauds. A second category of contracts that we're going to talk about will be brought into play by consideration of the parole evidence rule. And at this point, what we ought to say is that even if a contract does not have to be in writing, by virtue of the statute of frauds, it would make good sense oftentimes to have the contract in writing. That way we don't have to depend upon either the honesty or the memory of all of the parties to the contract. What they agree to is set forth in writing. And an example I use is personal services contract. If I were going to hire somebody to paint my house, I certainly would want to have some kind of a written contract so that myself and the painter would know not only the price, but what the painter is going to do, when is the job going to be done by, is the price paid all at once, or is it paid so much when the job begins, so much at the end of the job, those kinds of deals. We could have a verbal contract, but then again, we're trusting in each other's honesty and we're trusting in each other's memories. And I think for a contract of that magnitude, we'd be a lot better off. It would be prudent to have our contract in writing. But whether the contract is in writing because it's required to be so because of the statute of frauds, or simply because the parties to the contract agree that it's a good idea to have the contract in writing, we then consider the parole evidence rule. And the parole evidence rule says if we have a complete contract in writing, then neither party, or any party, if we have more than two, can introduce evidence in court, should there be a lawsuit, to establish that there is a understanding of the contract that is different from what's been set forth in writing. And the parole evidence rule is a rule of evidence, so we don't run into it until we hit a lawsuit. But the takeaway here, it would seem to be, practically speaking, if we're going to have a complete written contract, let's make certain that we understand that all of the agreement is in the written contract, and verbal side agreements, by way of example, or for that matter, written side agreements, if they're not connected to the main contract, may very well not be admissible in the event of a lawsuit. We can now go to our third category of this chapter, which is interpretation of written contracts. And the fact is, any written contract. Here we could be conceivably talking about a verbal contract, but likely it's a written contract. There's a part of the contract, a term or a phrase, perhaps just one word, that is ambiguous. In other words, the parties agree, yeah, this is in the contract, but they disagree as to what it means. We don't have any problem here with the parole evidence rule, but we've got to understand, well, how is that going to be sorted out? In other words, when we have a dispute about the interpretation, then how is that going to be resolved in court? And I gave you, which is actually a famous case that I posted, Friggle-Lamette, if I pronounced it correctly, versus BNS International Sales Corporation. And when you read the case, the court begins the case by saying, the issue in this case is, what does chicken mean? And what happened is the parties used chicken in the contract, and then they had two different categories of chickens based upon their size. And when the buyer received the chickens in the larger size, the buyer balked at accepting delivery because the buyer said, hey, these are just stewing chickens, and my understanding is that they would be younger but heavier chickens that would be suitable for broiling and frying. Put differently, a stewing chicken, which is a large whole chicken, isn't going to cost as much when you sell it retail, or you can't charge as much when you sell it retail as you can for younger chickens with more tender meat, which can be used for broiling and frying. So the court had to come to grips with, well, what did the parties mean when they used the word chicken? They didn't define chicken in any way. In this case, gives us a glimpse into how the courts go about interpreting ambiguous contract language. One thing the court will do if there's no definition in the contract itself is it will consider if the parties had past contracts using the same term. Then we end up with, underlining here or pointing to it, this notion of past practice. Perhaps if we look at past practice, we can see how the parties in the past reflected their understanding of what the term meant. In this case, there was no past practice, and the court then looked at trade practices, and when you read the case, you can see that the evidence on trade practice was all over the place in terms of what did chicken mean in the business of the wholesale selling of different sizes and parts of chicken. So at the end of the day, the court actually couldn't come up with a really clear understanding of chicken, which was to the detriment of the person bringing the lawsuit, the buyer, and the court said, well, if you can't prove that chicken means what you claim it to mean, then you haven't met your burden of proof. And I might add that the court also concluded that it was reasonable, a reasonable conclusion, because as the court noted at some point, given the price in the contract, it was likely that the parties probably understood chicken in the heavier category of pounds to mean stewing chickens. But that gives us a sense then of some insight, I hope, into this particular chapter.